jury convicted Assata Shakur of murdering a New Jersey state trooper. She was in prison for it when in 1979 she escaped, becoming a fugitive, and was later granted asylum in Cuba. Years after that, in 2013, the FBI made her the first woman on its most wanted terrorist list, with the FBI and New Jersey each offering a reward of up to $1 million, $2 million in all. Hold that hard center first. A trooper named Werner Förster was killed on the turnpike in 1973. So was Assata's companion, Zed Shakur. Assata was shot and captured, and a jury convicted her, and she does not, in the book, deny she was in the car. Keep all of that. Now set it against the rest of her record. In the case inventory her memoir lays out, the turnpike is the only prosecution that ended in a conviction. 4 other juries acquitted her. 3 more indictments were dismissed. So the label rests on a real conviction and a real escape, and then lets those 2 facts stand in for a courtroom record far more complicated than one word. That is the question this episode holds open. How does a government turn a person into its most wanted terrorist when nearly every other case it brought against her ended in an acquittal or a dismissal? And what do you do with the one that didn't? The story we inherit is that a wanted list is a kind of verdict, shorthand for what a person did. It comes apart the second you notice that the label and the courtroom record read like 2 different documents, and they don't match. We'll read the legend first, then the record, then the machinery the book says is under it, and then the killing that won't resolve. The legend shows up fully formed, and it shows up heavy. The list, the $2 million reward that the FBI and New Jersey put up together, the words that travel with her, cop killer, fugitive, all filed under the name she was tried on, Joanne Chesimard, not the name she chose. Every one of those lands like a finding of fact, and that is the job they do. Now, be fair. The conviction is real and the escape is real, and the book does not pretend otherwise. But watch what the label does around those 2 facts. It takes a verdict and a flight and lets them stand in for a whole identity. You hear wanted, and your mind hands you guilty on everything. You see $2 million, and you assume a jury sits behind every dollar of it. That reflex, letting the label do the work a trial is supposed to do, is the thing to keep your eye on. Because in the outcomes the memoir recounts, the count cuts the other way. Of the charges that reached the jury, 4 came back acquittals. The trials didn't agree with the poster. So let's set the outcomes against the foul. And let's be exact, because the categories matter. A bank robbery case in federal court in New York went first to a hung jury. The jurors could not all agree, so no verdict came. When that first jury broke, Assata wrote, quote, "A lone black juror had refused to convict us. He had heard us," end quote. Read that plainly, because it's the whole tension in miniature. In her telling, a room full of the government's evidence, and one juror who, after hearing the defense, would not put his name to the label. On the retrial, an acquittal. Then acquittals on 2 separate kidnapping charges, and an acquittal on the Queens Bank robbery. That's the jury column, 4 acquittals deep. Alongside it, 3 separate indictments dismissed before a jury ever saw them. 1 for insufficient evidence, 2 dismissed for failure to bring her to trial. Acquittals are one thing, dismissals are another. A hung jury is a third, and I'm keeping them separate on purpose, because the sloppy version of this argument is where it falls apart. But even kept honest, the pattern is stark. 4 cases that reached the jury ended in acquittal. The Turnpike murder trial ended in conviction. That's not a claim about her soul. It's a claim about a scoreboard. This is where we get slippery with ourselves. We're trained to file an acquittal we didn't want under the heading technicality, to treat a clearance as a loophole. An acquittal isn't a loophole. It's a binding legal outcome. It is also not the same thing as proof she was innocent, and I'll come back to that hard. But line these outcomes up against one label, and it's the label that needs explaining now, not the verdicts. The memoir argues that something beyond the courtroom shaped the public file. The only question left is what? This next move belongs to the book, so let me mark it clearly as the book's argument and not a proven fact. In Assata's account, the gap between the file and the record isn't bad luck, it's a program. The memoir quotes a panel of international jurists who reviewed cases like hers and placed her inside a named category of prisoner. As she quotes them, the panel found this class of prisoner, quote, selectively targeted for provocation, false arrest, entrapment, fabrication of evidence, and spurious criminal prosecutions, end quote. Sit with those words, because they aren't hers and they aren't mine. That is a finding she quotes, not one I can independently confirm, and it points at a real government counterintelligence campaign, the program that was aimed for years at Black political organizations. Now, the strongest objection deserves saying out loud. You can ask who convened that panel, what it reviewed, and whether a body already inclined to see it her way would have phrased it any other way. And a memoir will naturally reach for the finding that flatters its author. Fair. And that objection should make you keep one line very sharp. That a program like this existed and targeted these movements is documented by a Senate committee in the 1970s. That it produced each specific charge against Assata Shakur is her argument, not a proven fact. So hold the two apart. The campaign is real. The claim that it authored her particular file is the book's case, a serious one. And still a case, not a proof. If you credit it, the charges she kept beating weren't a run of honest mistakes the courts corrected. They were closer to the intended output of a system. There's a real difference between believing an institution erred and believing it was working as designed. And the book is asking you to consider the second. Hold that, because even at full strength, it leaves the hardest case standing. And now I have to turn against the reading I've just walked you into, because I keep circling back to one thing before I let us feel clean about this. If you followed the acquittals and the campaign this far, there's a conclusion sitting right there, and it's the comfortable one. She was innocent. The whole thing was a frame. Case closed the other way. I'm not going to let us land there, because the record won't hold it. The Turnpike case is the one the state won, and it's the one that matters most, and an honest reading walks straight into it. Her lawyers and the defense's medical witnesses argued that her wounds, an arm shot and left paralyzed, made the state's version of the shooting implausible for her body. That medical argument is the trial records, not the memoirs. What the memoir adds is the part underneath it. On the forensic help they wanted and couldn't get, Assata wrote, quote, "We could not find one forensic chemist to work for us, let alone testify for us," end quote. Weigh what that admits. It doesn't prove the shooting was impossible. It says the defense couldn't find even the one forensic chemist to try, in a trial she lost, for the killing of a man who is still dead. So we're left holding two true things that refuse to cancel out. The case was genuinely contested, and the case was genuinely lost. The contest over the evidence is real. The verdict is real. The trooper's death is real. This episode isn't going to tell you the jury got it wrong, because I can't prove that. And it isn't going to tell you she was innocent, because the record doesn't. What it can do is show you the seam, the exact spot where the state's file and the state's own courtroom record meet and won't line up. So the answer, in one sentence, you could argue with. A government can turn a person into a most wanted enemy the way this one was turned, by keeping a file that outruns its own verdicts. The memoir goes further and argues that a documented program helped produce the charges that file was built on, and the reward, the list, the label the size of a life, those came decades after most of the cases had already collapsed. While the one case that ended in a conviction, the one where a trooper was killed, stays legally settled and, in her account and among her defenders, disputed ever since. That's the book's case, and I've tried to give it to you at full strength, not because it settles anything, but because it's the half we're trained to skip. And then comes the move that keeps this honest, and it's ours to make, not the book's. We should turn that same question back on the memoir. Because the memoir that indicts the state's file is a file too. One its author wrote, from Cuba, with every reason in the world to shape it in her favor. The question that indicts the record, who wrote this and why, turns right back on the pages in your hand. And the acquittals that cleared her elsewhere don't clear her where a trooper died. Reading her honestly means turning down the comfort on both sides. If the memoir's argument is right, the label was shaped by forces outside the courtroom, including the campaign the book connects to her case, and the file isn't the truth about her. But if the Turnpike verdict is sound, then the one case that ended in a conviction went the other way, and no number of acquittals anywhere else undoes it. I keep coming back to that one juror, the one who had heard her and wouldn't sign. On the Turnpike, a jury heard her too, and they signed. Both of those things happen, and an honest reader doesn't get to keep only the one they like. Where I land is this: the file and the record are two different documents, and the work is to keep them apart, instead of collapsing them into a hero or a monster. The state kept one kind of record on her. She wrote another, and you're holding both.